It's a pleasure to see so many old friends here today and to come back and talk to you. It would be a lot more fun, frankly, to talk about my successful defense of the Sultan of Brunei and his brother than what we're going to talk about today. What we're talking about today is really pretty grim. But in the short time that I have this morning, I'd like to give you some of the salient facts relating to the death penalty in California and some of the recommended process reforms that our so-called FAIR Commission has recommended. In short, I mean, the bottom line is that the California death penalty system and its administration is dysfunctional. And I'm stealing, frankly, the words from our Chief Justice. Consider these facts. Today, California has over 670 inmates on death row. Since 1977, when the death penalty was reinstated here, we've had 13 executions. During that time, 38 have died from natural causes and 14 by suicide while on death row. And I might say that the numbers I'm going to be mentioning this morning are those that you will find in our Commission's report. And for those who are interested, want to see the report and want to find some of the background information on not only these recommendations but others, you can go to ccfaj.org. But the backlog is now so severe that we'll have to execute 5 prisoners a month for the next 11 years just to carry out the sentences of those who are on death row today. And based on the average number of death judgments that we're now experiencing here in California, which is down to about 20 a year, it had been up to about 40 a year, we will have around 240 new death judgments in the next 12 years. And so we'll have quite a bit to deal with even after we get past the backlog today. To focus on the delay, today it's estimated that it will take some 25 years from judgment to execution. That is double the national average of some 12 years as measured back in 2005. Why the delay? I'm going to leave this chart up for a couple of minutes. But if you look at it, you will see that it takes an average of some 4 years for the appointment of counsel on direct appeal. 4 more years for the filing of briefs from both sides. Another 2+ years for a decision by the Supreme Court on direct appeal. Now, Habeas corpus, a counsel is appointed by the Supreme Court sometime in that 10-year time frame, roughly 10 years after judgment. So it's 2 more years to denial of state habeas by the Supreme Court, 1 year to the filing of federal habeas, 6.2 years to a ruling on habeas by the United States District Court, over 2.2 years to a ruling on habeas by the Ninth Circuit Court of Appeals. And by the way, the federal courts have rendered final judgment in 54 habeas challenges to California death penalty judgments. Relief in the form of a new guilt trial or a new penalty hearing was granted in 38 of those cases. That's some 70%. Another year for a ruling on a cert petition to the United States Supreme Court, another year to execution, close to 25 years all total, and that number probably will grow unless something happens. It is not a pretty picture. All right, so what are the reasons? And what can we do about them? Now, some will say that our death penalty in California is too broad. Under the Briggs Initiative of 1978, 87% of California's first-degree murders are death eligible and can be prosecuted as death penalty cases. But as some of the DAs will tell you, they frankly prosecute a very small percentage of those as death cases. But under the Briggs Initiative, we removed the requirements of the pre-Briggs S statute that you had to prove the murder possessed an intent to kill. It removed the requirement that an accomplice be present and physically aided the death-causing acts before he or she could be eligible for the death penalty. And the Briggs Initiative doubled the number of special circumstances itemized under Penal Code Section 987.9. Keep this in mind. Modification of the death penalty, or narrowing it, as some have suggested, requires a supportive vote of the people. It can't be done by the legislature. Similarly, to abolish the death penalty entirely and go to life without parole, as some would recommend, requires a vote of the people. Well, we looked at those possibilities as a commission, and I think it's fair to say if you look at the separate statements at the end, we were very divided on those issues. There's some who are very strongly in favor of the death penalty that don't want to be regarded as supporting abolition, and others who felt the other way. So we didn't make a recommendation about either narrowing or going to life without parole. But we were virtually unanimous on a series of process reforms that, if implemented, would cut the amount of time, the 25 years, in half down to roughly 12 and a half years, which is the national average today. To achieve that would require some $100 million in additional spending, added to the $137 million that we've estimated is the present annual cost for administration of the death penalty. And that's looking at the system-wide cost of the system from trial court all the way up to execution. When you leave today, or if you're interested, you will see, I think at the MCLE desk, copies of our various process recommendations, and I think we have enough copies out there for just about everybody here. But let me just simply summarize them, and I know that other panelists will be picking up on some of these as we get into our discussion. One, to deal with the direct appeal processes, we would expand the office of the state public defender by 1/3 over 3 years to deal with the backlog of cases awaiting appointment. As of July 1st, 2008, there were some 79 defendants on death row who did not have counsel appointed. Second, you'd increase the size of the California Habeas Corpus Resource Center. Michael Lawrence, I'm sure, will be interested in talking about that. We recommended a 500% budget increase over 5 years to deal with the habeas backlog. Third, you would enlarge, Dane, I'm sure, would be supportive of this, the size of the Attorney General's office and its staff to meet the new demands brought about by the increase of those first two offices. And I might say, if private counsel are to be utilized here on the defense side, we urge that there be compliance with the ABA guidelines, section 44.1a, so that lawyers who are dealing with these cases are fairly compensated. Today, appointed habeas counsel are paid $145 an hour, and there's a $50,000 cap on investigative and expert services, which often proves to be insufficient. And if you look what they pay at the federal level, on federal habeas, it is substantially more. And clearly the amounts that we're paying are not sufficient to draw in the level of qualified, experienced counsel that we need. We also recommend that counties be fully reimbursed for defense services at the trial level under 987.9. We urge a re-examination should be undertaken on the restrictions on reimbursement of the counties and homicide trials. In short, state help should be provided to counties with death penalty caseloads. Now, once all those things are done, we recommend that serious consideration be given to Chief Justice George's proposal to permit the Supreme Court to transfer selected, fully briefed death penalty cases to the courts of appeal, provided, and big underline, provided, adequate staffing is provided to the courts of appeal and ongoing monitoring is provided by the Supreme Court. Now, some of our commission members and others in the bar have been concerned that this might add additional time to the time frames that I've mentioned. Maybe, maybe not. We'd have to see. It would certainly help the Supreme Court in its ability to deal with its caseload. But I think the bottom line is that taken alone, taken alone, it will do maybe some good for the Supreme Court, but it will not do a lot of good with respect to the 25-year time frame that I've outlined. We also recommend that serious consideration be given to encourage more factual hearings and findings in habeas corpus proceedings in death penalty cases, and require habeas petitions to be filed in the Superior Court with earlier appointment of habeas counsel, not 10 years, but pretty early on, while cases are still fresh. So you can find out whether there was something that was totally missed, let's say, in the trial proceedings that would be sufficient, for a habeas corpus grant. We also recommended the establishment of an ongoing death penalty review panel to report on the progress or lack thereof in reducing delays and recommending improvements in death penalty systems management, as well as comprehensive data collection on how death penalty cases are administered, in part to ensure that racial and geographic variations do not reflect an inappropriate exercise of discretion. I must indicate to you that wariness was expressed by many of the stakeholders, particularly coming from the prosecution area, many of whom felt that, county by county, it's our business and no one's else's business how we handle these cases. A substantial minority of our commission members, but a minority, oppose that data collection recommendation. Now, this chart would show the estimated impact on these reforms on the time frames involved. And you'll see, instead of 25 years, it goes down to somewhere in the 12 to 13, 14-year area. Again, there are some areas for even speeding it up further if it's done. I might say that in making these kind of recommendations, none of them shortcut an attempt to do justice in the particular cases. It's not a rush to judgment, obviously. 12 and a half years is not that. But it's a way of moving these cases with some deliberate efficiency that we simply do not have today. Now, let me talk a little bit about costs. It costs $90,000 a year more per year to house an inmate on death row than it does to house an inmate in the general population. The chart that I'm going to show you will give you an idea of the costs of the present death penalty administration under the current system. You can see that in the left column under the current system, $137.7 million. If we make the process recommendations, you will see that that goes to $232.7 million with declining amounts because the amount of incarceration would decrease. Again, that $90,000 plus per figure a year would be factored into that. If you narrow the death penalty with the worst of the worst, as identified by the Constitution Project, which found 5 special circumstances in 55% of our California death penalty cases, and if you put in place the prison or process reforms that we've recommended, the cost would be $130 million. And if you went to life without parole, you'd see that the final cost, instead of $137.7, would be $11.5 million. It seems to me that the choice is clear, although difficult, and it's simply this. It's put up or shut up. For those in Sacramento who favor the death penalty, and they may be in the majority, it's time to pay the price and have it administered appropriately. To those who are opposed to the death penalty, and they may be growing in this country, as best we can find out from the polls, put your opponents to the test. If they fail to act on the kinds of reforms that we have talked about, the courts certainly can't be blamed, as I think that they're subject to blame, certainly as people look at this today. But clearly, these kinds of things need to be done. And if reforms cannot be won in Sacramento and the kind of funding that we're talking about cannot be provided, then it seems to me that the option is to take these unfortunate facts to the people and seek reforms there. What we have today is something akin to abolition of the death penalty in California on a de facto basis. Our study, by the way, saw, of course, very few executions here, and it must be said that we were not able to find wrongful executions in California, that is, where factually innocent people were executed. Some other states, I think, cannot make that claim. But the failure of the death penalty, I think, in California, and the future of it is really a political issue, and will be, unless the courts at some time find that this delay, which may increase, constitutes cruel and unusual punishment for those who are on death row for such a long period of time. And if we're to achieve the reforms that we're talking about, or abolition, at least as it stands today, it's the body politic out there, the general population, that is ultimately going to have to take a leadership role. Thank you.
Well, I too am greatly honored to be present today. It's a fine occasion for us to continue the dialogue that we started with the Commission on the Fair Administration of Justice. And as John pointed out, we were composed of many different commissioners, people who believed fervently in the death penalty, people who adamantly opposed the death penalty on moral grounds, and people who simply thought that the system was broken because of what we examined. I did work at the ACLU, and so you know what my perspective is on the death penalty on a moral ground. But I am now, for the last 10 years, have been a government employee who has tried to manage a very large problem. And so my remarks actually may carry the tinge of partisanship of being an ACLU lawyer, but they are born in the reality of a system that simply does not work from a government perspective. And I'd like to talk a little bit about state habeas corpus proceedings, and particularly the causes of the problems that I see in capital punishment in California. First, I'd like to give a brief overview of the process. We have basically 3 different forms of review in all capital cases around the country, and these are the ones in California. The trial court judgment occurs in the county superior court. The automatic appeal goes directly to the California Supreme Court. An attorney is appointed, and the arguments that are raised down below in the record are raised in the automatic appeal. That decision then can be taken up to the U.S. Supreme Court. Hopefully, and I really truly believe hopefully, we would have a simultaneous habeas corpus proceeding. That is, a lawyer who is appointed soon after the judgment is looking at the issues that are not contained in the record. The automatic appeal looks at the objections that were raised below. It looks at the issues that could possibly be raised in the automatic appeal. Everything else is the domain of a habeas lawyer. The fact that our clients are mentally retarded, the clients that our lawyers were sleeping during the trial, those kinds of issues are the types of issues that habeas corpus lawyers are assigned to bring before the California Supreme Court. And currently, those petitions are filed in the California Supreme Court for many different policy reasons, not the least of which is to ensure uniformity of the standards for appointment of counsel. Those petitions obviously can go up to the U.S. Supreme Court, but once these 2 processes are finished, the case then advanced into the federal district court. And I will talk a little bit more about why my strong preference is to have these 2 processes finished simultaneously in a minute. The causes of the dysfunction, to me, I think, stem from really 3 inherent and interrelated problems in our system. The inability to manage the flow of cases into the system, the inability to appoint counsel and the lack of resources that we've assigned to these cases, and finally, the inability to correct errors in the capital judgments at earlier stages of the proceedings. And let me start with the first one. The inability to manage the flow of cases in the system really starts with the filing of a special circumstance allegation. That is what in Penal Code Section 190.2 determines whether or not a first-degree murder conviction is death eligible or not. There are currently 32 different special circumstances, depending on how you count the various ways in which your case can be a capital case. For example, the killing of a judge, the killing of a prosecutor, the killing of a juror, everything but killing of a defense lawyer in a courtroom. A remedy that I hopefully won't see, but almost everyone who could be killed in a courtroom could be the subject of a death penalty case. But the filing of the special circumstance allegation begins the capital process in California. I can't give you accurate statistics, and I apologize for that. But surprising as this might be, we do not track the filing of special circumstance allegations in the superior courts. We used to track them by the Office of the State Public Defender from 1977 to 1989, and so the statistics I'm going to give you are older statistics. But the yearly average of the special circumstance filings in those years was 278 special circumstances. Almost 300 cases were filed every year that could possibly be a capital case. Now, not all of them were charged in a way that the prosecution was going to seek death. Sometimes a special circumstance allegation is alleged, but the prosecution decides not to go forward with a death sentence. But let's start from the premise that many of these cases have to be treated as a capital case because they certainly can be turned into a capital case at any point in the proceedings. Of those 278 special circumstance allegations a year, less than 10% end up in a death sentence during those time periods. And that was a remarkably consistent figure every year. An average of 26 death sentences were imposed each year in that time frame. From a defense perspective, I think that's a rather good track record. We win 90% of our cases at the trial court level. But let's talk about the resource needs that we have to commit at the trial court level for those individuals. If we have 278 cases filed every year, roughly 400 to 500 of those cases are pending at any given time. It takes about a year to 2 years at a minimum for those cases to go to trial. And you look at the resources that you have to put into these cases at the trial court level compared to life without possibility of parole cases or first-degree murder cases, and the results are staggering. So when we look at the true cost of the death penalty at the trial court level, we are not looking simply at the cost of a life without possibility of parole prosecution versus a death prosecution. You are looking at 10 times that cost, because you have to account for the 9 cases that do not end up in a death sentence. The resource needs and costs for the California Supreme Court, even with 26 death sentences every year, are similarly staggering. And this brings me to my second point, which is the inability to appoint counsel and the lack of resources in the post-conviction setting. We currently have 81 cases without automatic appeal counsel. California Supreme Court has done a remarkable job of appointing counsel, reducing the backlog of automatic appeal cases awaiting appointment of lawyers. They have done a superb job of reducing that number almost in half over the past 10 years. That is still a very significant number of cases that we don't have lawyers for. And even more staggering is the number of cases that we don't have habeas corpus counsel. Because when the creation of my office by Senate Bill 513 split the function, the defense function, from a single attorney who was going to do both direct appeal and the habeas proceedings into 2 lawyers, we found more lawyers to do the direct appeal, but less lawyers to do the habeas corpus cases. We currently now have 301 cases. Almost half of death row don't have a lawyer for their state habeas corpus proceedings. And quadrupling the size of my office might be one solution. I can't imagine working in an office that large, let alone managing the number of people who would be having to be hired for that process. But quite frankly, that is the only solution that the Commission could come up with. Now, the reasons for the lack of counsel are myriad. There are concerns about the amount of money available for fees. $145 is certainly not a high hourly figure, but one that is doable for somebody who is representing people on death row. The difficulty, however, is that not every hour is compensated. We have limits as to how much we can pay people, and our benchmarks for appellate counsel are far better than they are for habeas counsel, simply because habeas cases are different. Every case is different. We don't know going into a case how much time it's going to take to investigate what we don't know in the record. But most importantly, I think the point that John made about the expenses. Habeas corpus expenses are capped at $50,000 before an order to show cause could be issued, before an order to show cause is issued. If you look at the amount of money that is spent on the cases that are successful at the trial court level, the life without possibility of parole cases. You look at the lawyers who did those kinds of cases and the kinds of presentations that were made at the trial court level. I estimate that it's 5 times the cost of what a death case is. Because you remember the resources that have to go into all those cases? They include having a shortage of trial lawyers who are skilled and capable of doing these kinds of cases. And the cases that I see coming into my office are the cases where the money was not spent at the trial court level. And we have a state statute that limits us now to $50,000 in the post-conviction proceeding. So you're not getting money at the trial court level because your lawyer may not be asking for it or because the judge is not authorizing it. And you are still going to be limited at the habeas level of $50,000. That is how the system works in the state court currently. And it is something that California Supreme Court has done a remarkable job of trying to change. Because it used to be $25,000 cap on expenses up until January of this year. But with the California Supreme Court's impetus, that was doubled to $50,000. And yet we still aren't seeing a large number of cases, a large number of lawyers coming forward. Advancing the automatic appeal without habeas corpus counsel is another issue. That chart I showed you before that says the automatic appeal is proceeding. Once you find a lawyer, you're able to have briefing done in the case. The case can be set for oral argument and it can be decided. But for the 300 cases where we don't have habeas counsel, that's what keeps me up at night. I feel like I'm Lucy. Do you remember the old Lucy show when she went to the chocolate factory? Everybody, well, I can see, I remember this, like I'm sure all of you can too, where Lucy was trying to get the chocolates off the conveyor belt and put them into the box so that they could be sold. And they sped up the conveyor belt, more chocolates started to fall, and she started sticking in her mouth, sticking them in her clothes. That's how I feel every morning. And let me tell you why. Once a direct appeal is finished, the federal statute of limitations begins to run. There's a 1-year statute of limitations for filing that petition in the federal district court. So the federal court time clock could be running when we don't have a habeas lawyer. And I am that Lucy trying to grab those cases off the direct appeal to make sure I can get something filed to stop that federal clock. And right now, my potential caseload is 300, and they're not chocolates. There are 300 cases which, if I don't do something, if the court is not able to stop the clock, we could have an execution because we don't have lawyers. That, to me, is a dysfunctional system. That brings me now to my third point, which is our inability to correct errors in capital judgments at an early stage of the proceedings. The California Supreme Court certainly spends the most time of any court that looks at capital cases around the country. California Supreme Court accepts larger briefs, issues longer opinions, and spends more time on these cases than any other Supreme Court around the country. Unquestionably, they take their task very seriously. Nonetheless, the affirmance rate by the California Supreme Court in capital cases hovers around 90% of the cases. 90% of the times, California Supreme Court affirms the death judgment or rejects the habeas petition. And I don't want to criticize the court because they are my employers. But I also want to put that into some perspective, and that is other states' experiences are far different. Other states' experiences, the average is 40% of a reversal rate around the country. That includes Texas, which is right now about 35%, Arizona, which is about 40%, Florida, which is much higher than that. States that have fairly large number of cases coming before them weed out cases earlier. Now, the perspective from the California Supreme Court versus the federal courts we will talk about in a minute. But at the very least, we are talking about a system that does not get rid of cases at an early stage in the process. Now, the error correction that does happen in our system happens in the federal court system. We are now looking at, as John points out, 70% of the cases in which there has been a final judgment on the merits, including U.S. Supreme Court review of that decision or denial of certiorari. 70% of the time, the case is sent back for a retrial. Now, you can say that the Ninth Circuit is aberrational, but let me make 2 points about this issue. One, it includes U.S. Supreme Court review, and the U.S. Supreme Court's not certainly hesitant to slap down the Ninth Circuit when it feels it needs to be slapped down. And we've seen a number of cases in which they have reversed even per curiam decisions. They have reversed the Ninth Circuit. But secondly, even more importantly, the empirical data shows that that is simply not the case. If you look at what the Ninth Circuit does in other death penalty jurisdictions within the Ninth Circuit, you find that their average of affirmance or of granting of relief is about the same as the national average. It's about the same as the Fifth Circuit, about the same as the 11th Circuit, where they are affirming the denial of relief or they're denying relief in about 60% of the cases. And what you look at in those particular jurisdictions is that the Arizona Supreme Court is a perfect example of that. Arizona Supreme Court reverses 40% of the cases. So if you add the reversal rate from the Arizona Supreme Court and the granting of relief from the Ninth Circuit, you equal about 70%, which means we are not weeding the cases out in the state court system. Now, my reason for that, I think the reasons for that are several-fold. First is the California Supreme Court takes care of habeas matters exclusively. Unlike every other jurisdiction, we go to the California Supreme Court to file our habeas petitions. And the California Supreme Court is a very good court, but probably not the most adept court at resolving factual disputes. That really is the trial court function. And the court is doing a very good job of, certainly in the last few years, of issuing order to show cause and reference orders to the superior courts. But the reality is, I think if we don't have some kind of trial court review of these cases, we are not going to weed out these cases at an earlier stage in the process. And secondly, and I'm not sure how to show this empirically, but once a case ends up in a life without possibility of parole sentence at the trial court level, you have no record that goes before an appellate court. If I win a case at the trial court level and I have a jury decision that I get life without possibility of parole, the penalty phase transcripts aren't even transcribed. Nobody sees the effect of that excellent trial work in an appellate court level. And instead, what we have are the cases going before the California Supreme Court, which are death cases. And those, obviously, those penalty phases are transcribed and those issues are raised before the California Supreme Court. But the California Supreme Court is not exposed to what a good lawyer does. The habeas issues that are raised in the California Supreme Court try to present that kind of evidence. But unless you have some sort of benchmark to look at, this is a good life without possibility of parole case. This is a good penalty phase defense that has been presented at the trial court level. I think it is very difficult for a court to say this is harmful error. And so returning these cases to the trial court level, I think will increase the number of grants of relief in state court, simply because the cases that the trial courts will be looking at can be compared against the trial court's own experience in life without possibility of parole cases. And in the event, it is very easy to describe the problems. It's a very more difficult thing to describe the solutions. One solution is to spend a lot of money we don't have. But other two panelists will talk about two other things that might be able to hopefully address some of the issues.
As we all know, of course, California provides an appeal as a matter of right from a criminal judgment, and in most cases that goes to the Court of Appeal with discretionary review available by the Supreme Court. But Article 6, Section 11A of the California Constitution provides that in the case of a death penalty judgment, that appeal goes directly to the California Supreme Court, a provision of state law, I think, that goes all the way back to statehood, and the court has long recognized that as a mandatory non-waivable appeal. So accordingly, the California Supreme Court must hear all the direct appeals that come from death judgments. Although it has the authority under Section 12 of Article 6 to transfer cases where appropriate to the district courts of appeal, they are expressly precluded by that section from transferring any of the capital cases. Last year, the Chief Justice estimated that capital appeals constitute 20% of the court's annual opinions. 5 of the 12 cases that the court will be hearing at oral argument in December are capital cases, and parenthetically, it's interesting to note that 3 of those are new death judgments following the granting of relief by federal courts. The court issued 26 opinions since January of this year just in the area of capital appeals. So one way that should be considered to perhaps alleviate some of this burden is the proposal the Chief Justice made last November to amend Article 6, Section 12 by allowing the court to transfer some number of fully briefed death penalty cases to the district courts of appeal for argument and final decision. It had been hoped that this could be, that this proposal could go on the 2008 ballot, but budget issues and concerns prevented that from happening. Now it has to result in a constitutional amendment. It can only result from a constitutional amendment because of the current prohibition of transferring cases in Section 12. The proposal that was outlined by the Chief Justice would allow, at least initially, as many as 30 cases per year that were fully briefed. Counsel would still be appointed by the Supreme Court. The briefing would take place there, but once the briefing was completed, the court would then transfer them to the District Court of Appeal, presumably the district from which the judgment arose. And then upon the issuance of a decision by the Court of Appeal, the Supreme Court would review it to determine whether it contained any error affecting the appellate court's judgment, whether it presented the need to secure uniformity of decision, or whether it required the resolution of an important question of law. If none of those conditions applied, the court could simply issue an order affirming the district court's decision. If the Supreme Court determined that any of those conditions were met, it would then order supplemental briefing as appropriate and oral argument and issue a written decision on any or all of the issues that had been before the Court of Appeal in the original briefing. In other words, it would allow the Supreme Court to pinpoint specific issues that might require further development by the Supreme Court. As General Van de Kamp pointed out, this issue was discussed before the Fair Administration of Justice Commission, and in its final recommendations suggested that serious consideration be given to the proposal, but only if the substantial additional funding that he discussed this morning were provided to various defense counsel. The Attorney General embraced this concept early on, and we continue to do so because we think that it is a proposal worth exploring more carefully as one means of lessening the delay in resolving capital appeals. If successfully implemented, certainly I think there would be a need for additional resources, particularly for the State Public Defender, and I suspect for the Attorney General's office. And the court, in its original proposal, indicated that it would be carefully monitoring the effect it might have on the staffing, research attorneys of the courts of appeal, and additional resources may be appropriate there as well. But we are not convinced, I'm not convinced, that we need to await the additional funding to conduct this experiment. What I think we need to do is amend the Constitution and allow the court the opportunity to transfer some of these cases. I think it's a reasonable approach to the problem, and one that's not likely to undermine uniformity in state capital jurisprudence. Certainly the Supreme Court, in its initial review, would have the opportunity to determine if any of the issues raised are ones that the court was concerned needed to be examined by it, because it has, they would have immediate necessary broad application to other cases before the court, or to new issues that had not yet been developed. But the fact is that a substantial part of the briefing and argument and resolution of issues in the capital cases are either guilt phase issues, which courts of appeal deal with on a regular basis now, or application of decisions that the California Supreme Court has already interpreted with respect to aspects of the penalty phase, and of course special circumstances, which again are issues that are already heard and resolved by the courts of appeal in the life without parole cases. I think that this approach would be one that would allow the court to effectively double the numbers of decisions in capital cases that are being provided each year. 26 opinions since January in capital cases. If 30 additional cases were transferred to the Court of Appeal, that's already going to double at a minimum the numbers of cases. And as and if the court were to determine that this was effective, that additional resources were necessary and provided, we could even increase the numbers of cases that would be heard by the courts of appeal. On the other hand, if it turned out that after a year or two of this approach that it wasn't successful, that there were concerns about uniformity, that the court found it necessary to effectively review all those cases again, and that it wasn't resulting in any savings of time, then it wouldn't need to make that transfer any further. But in order to be able to explore this more fully, in order to undergo this experiment, it is necessary to amend the Constitution in order to allow it the opportunity to make those transfers where the court thinks it's appropriate. Now, I think that the importance of exploring this issue is reinforced by developments last week in the election, specifically the passage of Proposition 9, Marcy's Law, as it's called, because that law created new rights for victims, broadly defined now to include not just the person who was the the person against whom the crime was actually committed, but their spouse, parents, children, siblings, guardians. And the rights that were created by Proposition 9 are personally held and enforceable by the victim, counsel for the victim, or by the prosecutor in any trial or appellate court with jurisdiction over the case. And among those newly established rights of victims is the right to a speedy trial and a prompt and final conclusion of the case. Now, we are obviously, at the Attorney General's Office, very carefully exploring all the implications of Proposition 9 and its application to us and how it's going to affect the handling of cases. I know all the district attorneys' offices are doing the same. But the fact remains that the people through the initiative process have now established certain rights that have to be taken into account. And the proposal that the Chief Justice put forward to transfer some of the cases to the courts of appeal for argument and decision could be one useful method of implementing that right by reducing the delay and allowing potentially the doubling, if not more, of the numbers of capital appeals that were resolved each year. And so Proposition 9, as is often the case when the electorate speaks, is yet another grounds upon which we should consider the importance of further reviewing this approach to perhaps speeding up the capital review process.
Thank you. Thank you for inviting me to participate in this discussion of the death penalty in the California Supreme Court. We've heard repeatedly, both in the words of the Commission and the words of Chief Justice George, that we have a dysfunctional death penalty system, and that capital cases have created quite a burden on the court. In California, as Attorney General Van de Kamp had said, we have what's generally thought to be the broadest death penalty statute of any jurisdiction in the country. And that fact may explain in part the court's current caseload problem. But in my view, there's a much more profound problem that arises from the scope of our death penalty statute. We've heard some discussion about stare decisis and what it means to have decisions dictated by precedent, and I think Justice Werdiger wisely pointed out that reasonable jurists can differ in their opinion about what is dictated by a certain case. In my view, I think the overbreadth of our statute directly conflicts with the Eighth Amendment. The United States Supreme Court has recognized two principles that are to limit the scope of death penalty statutes. First, a death penalty statute cannot define a class of crimes subject to capital punishment so broadly as to create a substantial risk of arbitrariness. This was their essential teaching in Furman versus Georgia in 1972, and a principle that's been reaffirmed ever since. Consequently, the High Court has said that legislatures as the representatives of the people must genuinely narrow death-eligible murders to a point where juries actually impose a death penalty on a substantial portion of those murderers who are eligible for the ultimate penalty. Second, the High Court has said that the death penalty is disproportionate as punishment for the average murder. Now, it's hard to talk about murders being average. All murders are horrific. But what the court has done with the Eighth Amendment is said that it is the responsibility of the legislature to create a hierarchy of the worst murders, and that the death penalty is to be reserved for those murders. We have Justice Scalia saying this, where he said that the death penalty is to be reserved for murders characterized by a high degree of brutality and depravity. We have Justice Souter saying this recently in the case of Kansas versus Marsh, where he directly said the death penalty must be reserved for the worst of the worst. But our death penalty statute, the Briggs Initiative enacted in 1978, does not genuinely narrow the death-eligible class in California to the worst of the worst. The scope of our statute derives from two sources. First, we have a very broad definition of first-degree murder. In Penal Code 189, we have 21 separate categories of first-degree murder, and the result is that virtually all murder in California can be first-degree murder. The broad scope of our death penalty statute also arises from the definition of our special circumstances. Our special circumstances are the statutory mechanism that define which first-degree murder can be penalized by death. And in our statute, we have 21 separately enumerated special circumstances that actually encompass 32 distinct types of murders, making almost all first-degree murders capital murders. As the Commission on the Fair Administration of Justice found, over 87% of first-degree murders in California are death eligible, and yet studies have shown, based on recent statistics from this decade, that fewer than 5% of these death-eligible murderers are actually sentenced to death. So our statute encompasses murders that I think everyone who thinks there should be a death penalty would say should be in a state's death penalty statute. It includes serial murders and multiple murders and torture murders. But our statute also includes what might be considered, if we can use this kind of term in talking about murder, run-of-the-mill murders. It includes accidental shootings during a holdup of a liquor store, and it includes a wife who murders her husband while he's asleep. These can be charged as capital crimes in California. So I think the overbreadth of our scheme violates the basic fundamental requirement of the Eighth Amendment that we have a narrowed class of death-eligible crimes. And it also violates a proportionality provision, because if we're including almost everything within our death penalty net, invariably the death penalty is going to be meted out in an arbitrary way. Empirical studies have confirmed this view about our death penalty and have shown that there are risks of arbitrariness, particularly in the areas of race of the victim and geography, county by county disparities in California. I think this is a harsh truth for people to accept who are concerned about a fair criminal justice system. But it's also a truth that was recognized over 35 years ago when Furman was decided. Justice Brennan recognized this problem when he wrote in his opinion in Furman, "When the punishment of death is inflicted in a trivial number of the cases in which it is legally available, the conclusion is virtually inescapable that it is being inflicted arbitrarily. Indeed, it smacks of little more than a lottery system." From my perspective, having done these cases for over 25 years, this is as true in California today as it was in Georgia at the time the Furman case was decided. Now, I don't think this situation is inevitable. I think there are remedies, primarily the narrowing of California's death penalty statute so it does not cast such a broad net and include almost 87% of all first-degree murders. The Commission has noted in its report various studies, both done in California and other places, that endorse this idea of narrowing the death penalty. First and foremost, this solution must be a legislative fix, and it will take political will. We need our legislators to talk honestly to the public about the financial costs of a system we have that everybody agrees is broken, about the dubious benefits that we're getting from the vast amounts of money we're spending, and the vast human resources that are being devoted to these cases, both from the defense side, from the prosecution side, from the court side.
Do you wish to give us the Rifkin list of what first-degree murders should be included as death eligible?
Do I want to give it? Well, I think that there are many reports that have suggested them. The Constitution Project, the Eleanor Moratorium. I did a study in. I did an Aubrey Review article based on a study in 1997 that suggested them. This is really ultimately what we have elected representatives for. What I think the list should be, if we're going to have a death penalty, I think serial murders, multiple murders, torture murders, murder of a police officer. I would limit it there. I think, but the line drawing is what we have.
Not murder of judges?
No, I don't think the risk is that great, actually. I don't put him in the same.
That's a relief.
I don't put him in the same risk category as a police officer. But, we can debate the line drawing. I mean, that's what the democratic process is about, because certainly a lot of people would say, no, you have to have children under 12 and you have to have old people over 70. But I think what we need to do is have the public realize that we need to engage in this discussion because we're paying a huge amount for a system that everybody has agreed on is dysfunctional. Personally, I would endorse abolition. I would argue against my own economic self-interest. I would argue myself out of a job. Do I think the California populace is ready to go there right now? No, I don't. But I do think that if the public is given the information that we have about how much money is being spent, particularly in this economic crisis, and whether it's where the public wants the money to go. Do we want to be spending money in the $137 million range per year that was cited, or would we rather reduce that cost, whether it's reduced by half or it's reduced by a third or whatever it is, and spend some of that money on education or infrastructure, whatever. But it's a discussion that has been lacking in the public, and I think we need to have it there. Now, while I think that the solution must be primarily legislative, I think there are judicial remedies. Although, with all due respect to the court that's sitting here, they have routinely and consistently rejected these claims. The California Supreme Court could take the mandate of Furman seriously and could hold that the California death penalty scheme is unconstitutional because it fails to narrow the death-eligible class. The effect of such a holding would force the legislature to do what we're talking about. Go back and figure out what kind of focused, narrowed, and effective death penalty the California people want. The court alternatively could hold that the death penalty is unconstitutional for average murders, including felony murder. California is one of only 6 states of the 39 death penalty jurisdictions that imposes death for felony murder simpliciter, that is, for an accidental killing during a felony. We could limit the death penalty in that regard. I think the court has been given arguments that the death penalty is disproportionate for an accidental killing during a felony. Finally, the court could require comparative proportionality review to guard against the arbitrariness of disparate results in similar cases across the state and among co-defendants in the same state. This is a safeguard that has been adopted in other death penalty states like Florida and Georgia, but not in California. So in addition to discussing how the court might process capital appeals and habeas petitions more efficiently, which is certainly a very important topic, we should be asking more fundamental questions about the way our state has defined capital cases. Narrowing the scope of our death penalty statute may not solve all the problems with our capital punishment system, but it would be a huge start. And it might go a long way toward resolving some of the problems, like shortage of qualified counsel and the court's heavy death penalty docket.
I will just take the prerogative of the chair to give you one more piece of datum, and that is that I was informed that in this county, the county of Alameda in which we sit, last year the district attorney's office was challenged to review approximately 100 cases in which death eligibility was a possibility. Of that number, 2 cases were charged with special circumstances seeking the death penalty. So there are a number of ways that a human system is managed by human beings with various levels of responsibility. And in the end, ladies and gentlemen, I suggest to you that we get the system that we insist upon, and that this is a question for all people of goodwill to look at with great information available to them. And I want to thank our panel this morning for giving us such a great deal of information. And thank you for your participation. We're going to take a break for lunch.